what they should do and how they proceed in this sort of matter. But again, Judge Randall was having trouble reading, as you probably noticed, and taking some breaths, and then just said, I can't do this anymore, I need to take a break, and that he was in some pain. So just a little worrisome here. We're all hoping that Judge Randall's going to be okay. They did take, again, Anthony Garcia out of the courtroom, and everyone's just inside waiting to see what happens. Alexandra and David, back to you in the studio.
And Michelle, while we have you here, you were sitting right behind Anthony Garcia during this process. Can you describe his demeanor as the judge started reading the sentencing order, even the victim impact statements?
He didn't move. He's just been slumped over in that wheelchair. The only time he would move is if his head was forward or his head would go back or to the sides. I couldn't tell, but I believe his eyes were closed the entire time. He didn't make any noises. At one point, his brother tried to move up to the front row, to get closer to him, but the family members are not allowed in the front row, just press law enforcement and court personnel, so he had to move back to the second row. But no, hasn't made any statements. Like I said, just appears as he's asleep and unaware or uninterested in what's happening with his death penalty sentencing here today. But yeah, not a peep out of him or any type of reaction. I was sitting in front of his parents, and his mother a few times shed some tears during those victim impact statements. His father and his brother, looking down a lot, and just quietly listening. Not a lot of. This proceeding's been going on for a long time, so everyone involved in this case are used to waiting. They've just gotten used to being patient and listening intently on what's happening here. But back to your original question about Anthony Garcia, no reaction out of him whatsoever. David?
Now, Michelle, back to the moment when Judge Randall started struggling to get through that order. You said things remained pretty calm, but can you describe the reaction of others that were in the courtroom who really didn't know what was going on at that point?
Well, I think that everyone was just surprised. They didn't know what was happening. And so everyone just listened to the judge, as they do. Like I said, he was very calm about it and very polite, and kind of like, excuse me while I get up here, from the bench. And so the reaction of everyone else was they stood up. No one knew really what was happening, or if he was going to collapse right there after he said he needed to excuse himself. So court personnel did escort him out into the chambers, and I think everyone was just kind of looking around, wondering what's happened, but nothing chaotic, just very calm and just dealing with the situation. And he had people with him, Judge Randall had folks with him right away, and just kind of wondering what happens, what do you do in this proceeding? And I'm sorry, I'm just going to keep looking while you're asking me questions.
All right, and Michelle, while you're checking in there, you talked a little bit about the reaction of those in the courtroom. We could not see Judge Randall. Did he appear to be in distress when this was happening?
Well, for a while there, I thought maybe was he getting emotional as he read this, because, he is personally involved with this case as he's followed it through. And that was just what I personally was thinking was he getting emotional here? Because like I said, he was taking some deep breaths as he was getting through reading the court order. And then after a while, it kind of became apparent that something was wrong. And so he just looked like he was in pain and that something was wrong and he needed to take a break. So it wasn't, like I said, anything I'm not sure what word I'm looking for, but he was very polite. That's all I can see today. He was very polite and calm about the whole situation, just saying, I need to take a break here. And that's what happened.
Michelle, stay with us here. We're looking live inside the courtroom right now. You can see Douglas County Attorney Don Klein and his Chief Deputy Brenda Beadle there, along with some defense lawyers as well. They were just in chambers. Michelle, can you kind of describe what the other judges' reaction
else is witnessed in the courtroom.
Okay, so they brought Mr. Garcia back in, and so, I mean, we just proceed as if,
We'll wait and see. We'll have to just wait and see. But you have more information than I do, sounds like.
but your reaction as a clerk of court.
Yeah, it's alarming. Hate to see anybody have to be rushed to the hospital in any fashion like this, whether it's a 3-judge panel death penalty hearing or sentencing, or if it's just a normal routine case where we're a family down here. We like to see everybody get through the day and go home like they're supposed to, and that's not the case right now. So yes, everybody's very concerned.
Well, and of course, we're thinking of kind of flashback to Judge Ashford and his passing here at the courthouse.
Absolutely. It's alarming. So we're keeping a good thought.
And so from what I understand, he recently had back surgery?
I can't comment on that. I don't know.
Okay, all right. Thank you, John Friend. Again, they brought Anthony Garcia back into the courtroom, as you know, and they will be beginning the court proceeding and finish reading the sentence of this death penalty ruling here today. Back to you guys.
Really interesting here to hear that from the clerk of court, that he's never seen anything like this happen. And he mentioned that this 3-judge panel death penalty hearing is rare in any case, and then to have it sort of stalled in this fashion.
Yeah, John Friend as well.
All right.
Okay,
Back
judges
on
are
the
back.
record.
Let's continue.
State of Nebraska versus Anthony Garcia, CR 13-2322. Prior to going off the record, I think it was apparent that Judge Randall was experiencing some difficulty. Had a procedure this week that resulted in some back pain as a side effect, and I think he carried it out as far as he could today. I know Judge Randall, he would have continued if he could. He couldn't. At any rate, Judge Bowie and I have conferred and decided that if there is no objection going forward, then we will do so. Is there any objection from the state?
No, Your Honor.
Any objection from the defendant?
Your Honor, we have to object for the record. The Nebraska statutes don't address this particular situation. Obviously, it's highly unusual for a defendant to be sentenced in the absence of one of the sentencers, the judge. In this case, the presiding judge. It's obviously highly unusual, and it seems like the better course would be to complete this hearing at another time when Judge Randall could be present.
Thank you, Mr. Pickens, and I would agree it is highly unusual. I will tell you for the record that this order was signed by all 3 judges, including Judge Randall, prior to going on the record. All we're doing, and I think Judge Randall acknowledged the fact, as we're reading it into the record, having all 3 signatures attached to it, this order can be filed, be made effective yet today. So I'm going to overrule your objection. As I recall, we were discussing psychiatric and psychological treatment. So I'm going to proceed with the order. There's evidence the defendant sought psychiatric and psychological treatment, and at times was prescribed medication as part of that treatment. In the panel's view, the defendant's psychiatric or psychological history does not rise to the level of a mitigating circumstance to the actions taken by the defendant in the commission of the murders of Thomas Hunter, Shirley Sherman, Mary Brumbach, Roger Brumbach. These murders were separated by 5 years, during which time the defendant worked full-time as a physician, supported himself, purchased a home, and demonstrated he was capable of being a law-abiding citizen. Section D, Proportionality. Panel is required to determine the propriety of a death sentence by conducting a proportionality review. Such sentence determination shall consider whether the sentence of death is excessive or disproportionate to the penalty imposed in similar cases, considering both the crime and the defendant. Nebraska Revised Statute 292522 subsection 3. See also Vela, State v. Mata, State v. Dunster. This review requires a panel to compare the aggravating and mitigating circumstances in the case before it with those present in other cases in which a death penalty was imposed. The purpose of this review is to ensure that the sentences imposed in this case are no greater than those imposed in other cases with the same or similar circumstances. Supreme Court has stated a proportionality review does not require that a court color match cases precisely. It would be virtually impossible to find murder cases which are the same in all respects. Instead, the question is simply whether the cases being compared are sufficiently similar, considering both the crime and the defendant, to provide the court with a useful frame of reference for evaluating the sentence in this case. The panel has undertaken a review of the Nebraska cases in which a death penalty was imposed as part of this proportionality review. The panel has mapped and considered all cases contained in Exhibit Number 1, which will be attached to this order. It also considered the opinion of the sentencing panel in State v. Jenkins, District Court of Douglas County, case number CR 13-2768, CR 13-2769. These cases are currently on appeal to the Nebraska Supreme Court. The panel first considered the defendant's murder of Thomas Hunter, Shirley Sherman, and subsequently Roger Brumback and Mary Brumback in relation to the murders and other cases in which a death penalty was imposed. There exists no precedent in Nebraska law for the fact that the defendant traveled from his home in Indiana to Omaha, Nebraska to commit 4 murders on 2 separate occasions, separated by a period of 5 years. Those facts suggest lengthy premeditation and an exceptionally depraved mentality. The defendant had 5 years to reflect on the gruesomeness of the first 2 murders before he returned to Omaha to commit 2 more murders that were as equally gruesome. His actions indicate he had no remorse after the first 2 murders. In fact, the trial evidence suggests he bragged about them in an attempt to gain favor with the female he wished to engage in a romantic relationship. The defendant continues to evidence no remorse, and the panel finds nothing to suggest that he ever will. After a complete review of the cases referenced above, the panel unanimously concludes that the murders of Thomas Hunter, Shirley Sherman, Mary Brumback, and Roger Brumback, when compared directly to the murders in which the sentence of death has been imposed, a sentence of death in this case would not be excessive or disproportionate. The panel has considered the relative proportionality of the prior conduct of the defendants who were sentenced to death. The defendant now stands convicted of 4 murders. There is no doubt that all 4 murders were premeditated, yet there are any number of cases in which a defendant was sentenced to death in Nebraska where the prior conduct did not rise to the level of disregard this defendant has for the value of the life of another human being. Other cases in Nebraska involving more than 1 murder have been closely scrutinized. See State v. Jones, State v. Jubert, State v. Ryan, State v. Lauder, State v. Williams. All these defendants were sentenced to death. For example, in State v. Hessler, Hessler was sentenced to death based in part upon findings that he had substantial history of serious assaultive or terrorizing criminal activity. The murder was committed in an effort to conceal the commission of a crime, and the murder was especially heinous, atrocious, cruel, or manifested exceptional depravity. Hessler had not been convicted of a prior murder. Jubert involved the defendant convicted of 2 counts of first-degree murder for the killing of 2 young boys. Jubert was sentenced to death in each case based partly on the finding that he had a substantial history of serious assaultive or terrorizing criminal activity. Jubert had not been convicted of a prior murder. The panel also notes that the death penalty was imposed in State v. Gales and Williams. Gales was sentenced to death based on findings that he had previously been convicted of a crime of violence, as well as the particulars of the instant crime, but not a prior murder. Williams had previously been convicted of a crime of violence, but not a murder. In summary, the panel has conducted a thorough review of the death penalty cases and considered whether the sentence of death is excessive or disproportionate to the penalty imposed in similar cases, considering both the crime and the defendant. The panel has reviewed the nature of the murder in each case, as well as the prior criminal conduct of the defendant, which supports the ultimate finding that the death sentence was appropriate in each of those cases. The panel concludes the sentence of death for the defendant in each of those murders is neither excessive nor proportionate to the penalty imposed in similar cases. Conclusions. The jury found beyond a reasonable doubt all of the aggravating factors alleged. The panel finds that giving the defendant the benefit of all inferences, there's one statutory mitigating factor, and that being the defendant has no significant history of prior criminal activity. Further, the panel does not find the existence of any non-statutory mitigating factors, and the panel finds that a sentence of death is not excessive or disproportionate to the penalty imposed in similar cases. All findings are made unanimously and beyond a reasonable doubt. Sentence. It is therefore ordered, as to count 1, murder in the first degree, a Class 1 felony of Thomas Hunter, on or about the 13th day of March 2008, the three-judge panel orders that a sentence of death is imposed upon the defendant, Anthony Garcia. As to count 2, use of a deadly weapon, not a gun, to commit a felony, a Class 3 felony, the presiding judge orders that defendant Anthony Garcia is sentenced to not less than 19 years, no more than 20 years imprisonment. This sentence shall be served consecutively to the sentence served in count 1 as provided by law. As to count 3, murder in the first degree, Class 1 felony of Shirley Sherman, on or about the 13th day of March 2008, the three-judge panel orders that a sentence of death is imposed upon the defendant of Anthony Garcia. As to count 4, use of a deadly weapon, not a gun, to commit a felony, a Class 3 felony. Presiding judge orders that defendant Anthony Garcia is sentenced to not less than 19 years nor more than 20 years imprisonment. This sentence shall be served consecutive to the sentence in count 1, 2, and 3 as provided by law. As to count 5, murder in the first degree, a Class 1 felony of Mary Brumbach, on or about the 12th day of May 2013. The three-judge panel orders that a sentence of death is imposed upon the defendant, Anthony Garcia. As to count 6, use of a deadly weapon, not a firearm, to commit a felony, Class 2 felony. Presiding judge orders that defendant Anthony Garcia is sentenced to not less than 49 years, nor more than 50 years imprisonment. This sentence shall be served consecutive to the sentences in counts 1, 2, 3, 4, and 5. And as to count 7, murder in the first degree, a Class 1 felony, Roger Brumbach, on or about the 12th day of May 2013, the three-judge panel orders that a sentence of death is imposed upon the defendant, Anthony Garcia. As to count 8, use of a deadly weapon, firearm, to commit a felony, Class 1C felony. Presiding judge orders that defendant Anthony Garcia is sentenced to not less than 49 years nor more than 50 years imprisonment. This sentence shall be served consecutive to the sentences in counts 1, 2, 3, 4, 5, 6, and 7. And as to count 9, attempted burglary, a Class 4 felony, presiding judge orders that defendant Anthony Garcia is sentenced to not less than 20 months nor more than 5 years. This sentence shall be served consecutive to the sentences imposed on counts 1, 2, 3, 4, 5, 6, 7, and 8. It's further ordered the clerk of the district court shall deliver a copy of this judgment, a sentence, to the warden of the Nebraska Penal and Correctional Complex or other proper and qualified officer charged with the execution of this sentence. Such copy shall serve as the order and direction to execute this sentence by inflicting the punishment of death by whatever method may be enacted by the Nebraska legislature. It's further ordered a signed or certified copy of this judgment sentence shall be delivered to the Sheriff of Douglas County, Nebraska, who shall promptly deliver defendant Anthony Garcia to the warden of the Nebraska Penal and Correctional Complex. And further ordered that in accordance with the Nebraska statute, the court reporter shall prepare a bill of exceptions as in other cases, and the clerk shall prepare and file with the clerk of the Nebraska Supreme Court a transcript of the record of the proceedings and any other records required by the Supreme Court for which no charge shall be made, in order that the required automatic review of this order of sentence may be made by the Supreme Court as provided by law. Stated this 14th day of September 2018. This order is signed by the presiding judge, Gary Randall, Russell Bowie, and myself, Rick Schreiner. Anything further, counsel?
No, Your Honor.
Mr. Garcia, you are remanded to the custody of the Douglas County Sheriff for execution of this sentence. We're adjourned. Thank you.
All right, and you can see Anthony Garcia.